Welcome to the Funeral Channel Network podcast. We are back with another deep dive, and today we are tackling a subject that sits right at the intersection of two things human beings are, let's be honest, notoriously bad at dealing with.
Oh, yeah.
Mortality and bureaucracy.
That is quite the combination. Yeah. It's the ultimate things we'd rather not think about cocktail, isn't it?
It really is, exactly. But here is the thing, and stick with me because this is important. We are going to argue today that this specific topic, this pile of paperwork we are about to discuss, is actually one of the most profound logistical puzzles you will ever solve. And solving it correctly is, I think, arguably an act of love.
It really is. It's a puzzle that usually gets dropped in your lap at the worst possible moment.
The absolute worst. So, let's set the scene. We're talking about the immediate aftermath of a loved one passing away. The source material we are diving into today is titled Legal Foundations for Postmortem and Funeral Arrangements.
Right.
Now, I know that title sounds dry. It sounds like something you'd read to fall asleep.
It does have a certain sedative quality to the title, sure.
But the reality it describes is, it's anything but sleepy. It describes a moment of really high-stakes tension. You have the emotional grief, shock, maybe a sense of time stopping. And then instantly you have the legal reality, which is just this flood of confusion, urgency, and administrative responsibility.
That's the core tension we need to explore. It's the collision of two very, very different worlds. You have your internal world of mourning, which is slow, it's heavy, it's deeply personal. You just want the world to stop.
Yeah.
But then you have the external world of the law, which is fast, it's rigid, and it's incredibly bureaucratic. And the law, it does not stop.
It doesn't care how you're feeling.
Not at all.
And the promise of this deep dive is that we are going to give you the roadmap to navigate that collision. This isn't just about filling out forms. It's about understanding why the forms exist so you can move from, confusion to clarity.
And the mission of this discussion, if you want to call it that, is to prove that legal documentation acts as the quiet enabler of a meaningful farewell. You literally cannot have the funeral, the cremation, or the burial without these specific keys to unlock the process.
So let's try and debunk the myth that bureaucracy is just the enemy of grief. Let's see if we can prove that legal preparedness is actually a form of care.
I think we can, absolutely.
Okay, let's start with section 1, the why. Why does the law get involved so aggressively and so immediately? Because when you read through the source material, you get the sense that the moment a heart stops beating, a stopwatch starts ticking.
It does.
Yeah.
It absolutely does. And to understand why, you have to look at the situation from the perspective of the professionals involved. The funeral directors, the crematories, the cemeteries.
The source material describes this concept of a stop sign. What's that about?
Right, the stop sign. So imagine a family in that immediate aftermath. Grief arrives with what the text calls overwhelming force. You're in a fog. Time feels compressed. Naturally, the family wants to do something.
Of course. You want to take action.
You want to take action.
Yeah.
They want to focus on memories. They want to call relatives. They want to pick out flowers. They want to set a date for the service.
I want to feel like they are making progress, like they're in control of something.
Exactly. But here's the hard reality check. The funeral home, the crematory, the cemetery, these are businesses, yes, but they're highly regulated businesses.
Right.
They effectively have a giant legal stop sign held up in front of them. They cannot proceed 1 inch without specific written authorizations.
So if I walk into a funeral home 3 hours after my dad dies and say, I want to cremate him and have a service on Thursday, they literally can't just say, okay.
No, they can't. They might nod sympathetically, they'll get you a cup of tea, but in the back of their mind, a checklist is running, and until the legal paperwork is signed, nothing moves.
Wow.
And this brings us to the consequences of unpreparedness. If those documents are missing, or if the authority to sign them isn't clear, the entire process grinds to a halt.
And we aren't just talking about a 5-minute delay, are we?
No. We are talking about cremation being legally blocked.
Yeah.
Burial permits being denied, services being delayed by days or even weeks.
Oh, that's a nightmare.
Imagine having family fly in from across the country. Everyone is ready to say goodbye. You've booked the church, and the funeral director has to sit you down and say, I'm so sorry, we can't proceed because we're waiting on a signature from an estranged brother who lives off-grid in another state.
That is the nightmare scenario. It adds a layer of logistical horror on top of the emotional horror.
It does. And in some cases, it's even worse than just a delay. If the legal paperwork isn't right, the personal wishes of the deceased might be overridden entirely.
What do you mean?
If you didn't write it down in a way the law recognizes, if your wish for cremation is just something you told your friend over coffee, it effectively didn't exist in the eyes of the law. The legal next of kin can choose burial, and there's nothing your friend can do.
That is terrifying. But let's play devil's advocate for a second. It all sounds so cold. It sounds like the state is intruding on a very private family moment. Why is it set up this way?
It feels cold. Absolutely. I get that. But if you flip the perspective, as the source material suggests, it's actually about protection. This isn't bureaucracy for the sake of bureaucracy.
Okay.
It's about verifying two things: identity and authority.
Verifying authority. So who's in charge?
Exactly. Who's in charge? Think about it. We are dealing with human remains. The state has a compelling interest in ensuring that the person who died is who we say they are, and that the person making decisions actually has the right to make them.
Right.
It protects the deceased from being handled in a way they wouldn't want, like being cremated when their religion forbids it, and it protects the family from the wrong people making irrevocable decisions.
So in a way, the stop sign it's a safety mechanism. It's a guardrail.
It is a crucial one. And when you reframe it that way, legal preparedness becomes the foundation of the memorial. The resources like the funeral program site, which were referenced in our reading, they emphasize this constantly. You cannot build the house, the service, the eulogies, the gathering without the legal foundation.
Act decisively rather than reactively. That was a phrase from the material that really stuck out to me.
That's the goal. That's the entire point. If you have the legal stuff sorted, you are executing a plan. You aren't reacting to a crisis. You are in control at a time when everything else feels completely out of control.
All right, let's get into the weeds then. Let's talk about the specific documents. The source material calls one specific document the cornerstone or the master key, the death certificate.
The death certificate. It is, without a doubt, the single most critical document in the entire process. There's no close second.
Most of us know what it is vaguely. It's a piece of paper that says someone died, but legally, what is it actually doing?
Okay, so legally, it is the official record issued by state or local vital records offices. It serves as proof of death, yes, but it contains all the crucial identifying information and, most importantly, the certified cause of death.
And why is this the master key? Why do we call it a bottleneck?
Because without it, almost every subsequent door is locked. You want a burial permit.
Need a death certificate.
You need a death certificate. You want to transport the remains across state lines to be buried in a family plot.
Need a death certificate.
You need a death certificate. You want the funeral home to legally take custody of the body in some jurisdictions. You need that certificate filed. It's the domino that has to fall first to knock over all the others.
So it's the prerequisite for everything.
Everything.
And the logistics of getting it. I imagine this can be surprising to people who haven't been through this. It's not instant, right?
Not at all. It requires a medical professional, an attending physician, a medical examiner, or a coroner to certify the cause of death. They have to sign off on it. Then the funeral home has to take that information and file it with the government. This all takes time.
And I assume accuracy is a really big deal here.
Huge. The source stressed this heavily, and it's true. If there is a typo on the death certificate, say the wrong middle initial or an incorrect Social Security digit, it can cause months of pain.
Months for a typo.
Oh, easily. Because to fix it, you have to file for a legal amendment. And while you are waiting for that amendment to be processed, which can take a very long time,
You can't do anything.
you can't close bank accounts, you can't claim insurance, you can't settle the estate, the IRS, the bank. They see a mismatch between their records and this legal document, and they just say, no, everything is frozen.
Wow. Speaking of bank accounts and insurance, there is a very practical takeaway here that I want to highlight. The certified copy rule.
Yes, this is the advice everyone forgets until it's too late. It is so important.
The advice is do not just get one copy.
Never just get one. The standard recommendation, depending on how complex the person's affairs are, is to order between 5 and 10 certified copies right at the beginning.
10 copies. That sounds excessive. At $20 or $30 a pop, that adds up pretty quickly. Why on earth would I need 10?
Because we live in a siloed world. The bank needs an original certified copy to close the account. They often won't take a photocopy because, photocopies can be forged.
Okay, that makes sense.
The life insurance company needs an original. Social Security needs to be notified with one. Pension funds need a copy. The DMV needs a copy to cancel the license and title. If the deceased had stocks or bonds, that transfer agent needs a copy. Each one wants their own original raised seal copy.
And they don't give them back, or not quickly, at least.
Sometimes they do, eventually. But imagine the scenario. You send your only copy to the life insurance company. They say it'll take 4 to 6 weeks to process. Meanwhile, the bank is calling, the mortgage company is sending letters, and you are stuck just saying, I'm waiting for the mail. It's incredibly stressful.
So you're paralyzed.
Completely. So the rule of thumb is to get more than you think you need. It costs a little bit of money up front, maybe a couple $100, but it is the cheapest insurance against frustration you can possibly buy.
That is a solid, solid tip. Get 10, put them in a folder. Don't be stingy with the certified copies.
Absolutely.
Okay, moving on to section 3 of our deep dive. We've got the death certificate. Now, who is actually in charge? This is the authorization hierarchy.
And this is where families often fracture. This is the big one. There's a widespread misconception that anyone who is close to the deceased can sign off on funeral arrangements.
Right. The I'm his best friend, I know what he wanted argument.
Exactly. Or I'm his living girlfriend of 20 years. It feels like it should count for something.
And the law says, not so fast.
The law says, show me the list. Every state has a statutory hierarchy, a legal list, that dictates exactly who has the right to control the disposition of the remains. It is a rigid, unforgiving list.
So let's run through this hierarchy. Who is usually at the very top?
Usually at the very top is a designated agent. This is someone the deceased specifically appointed in a legal document before they died to handle their funeral.
So you can pre-appoint someone.
Yes. And if that document exists and it's valid, that person trumps everyone else. Your spouse, your kids, everyone.
Okay, but what if that document doesn't exist?
Yeah.
Which is probably most of the time.
Right, most of the time. Then we go to the default list. Ending in line is almost always the surviving spouse.
Even if they were separated.
In most states, yes. Unless they were legally divorced, a final decree of divorce has been issued, the estranged spouse often has more legal rights than the supportive partner who wasn't married.
That seems like a recipe for some serious drama.
It is a frequent source of drama. You see these awful cases where a couple has been separated for 10 years, haven't spoken, but never finalized the divorce, then one of them dies. The partner who has been there for the last decade, who cared for them while they were sick, has zero legal standing.
Wow.
The estranged spouse has to sign everything.
And if the estranged spouse is bitter or just wants to be difficult?
Exactly. Or what if they're just hard to find? It creates absolute chaos for the people who are actually grieving.
Okay, moving down the list. After the spouse.
Usually it's the majority of the adult children. Then the deceased's parents. There's the majority of the deceased's siblings.
The danger of ambiguity section in the source really highlighted this. It talked about the emotional toll when this isn't clear, especially with adult children.
Right. Imagine a scenario where there is no spouse, but there are 3 adult children. 2 want a traditional burial back home, and 1 is adamant that dad wanted to be cremated. Who signs?
Do they vote? Is it majority rule?
In many states, you need majority agreement. So in that case, the 2 who want burial would win. But in some states, you might need unanimous agreement, especially for something irreversible like cremation.
So if they can't agree?
If they can't agree, the funeral home essentially freezes. They cannot proceed. They will not put themselves in the middle of a family lawsuit.
So the body just sits there in the funeral home's care?
Yes, in refrigeration. Until the family resolves it amongst themselves, or, in the worst cases, a judge issues a court order telling them what to do.
That is just heartbreaking, to be fighting in court over your parents' body.
It is. And that's why the expert insight here is so crucial. Disputes arise when authority is unclear. The funeral home has to verify who holds the legal right.
Yeah.
They aren't trying to be difficult. They're protecting themselves and, in a way, protecting the deceased from an improper disposition. They do not want to get sued for cremating someone when the legal next of kin wanted a burial.
Which leads us perfectly into Section 4, the specifics of disposal. Why is there such a massive legal difference between cremation and burial? The source material says cremation is stricter.
Much, much stricter. And the reason is simple physics, really. Cremation is irreversible.
You can't uncremate someone.
Exactly. You just can't. If you bury someone in the wrong plot, or if a long-lost family member shows up a week later with a court order saying, I have evidence he wanted to be buried in Florida, you can disinter the body.
Right.
It's unpleasant, it's expensive, but it's possible. Once cremation happens, the body is gone. Any potential evidence for a criminal case is gone. The opportunity for a different ceremony is gone. It is final. Utterly final.
So the cremation authorization form is What? It's not just a simple permission slip.
Oh, not at all. It's a rigorous legal document. It requires explicit written consent. It's not something you can just do over the phone.
Okay.
The form typically covers three main things. One, confirming the identity of the deceased. Again, crucial. Two, confirming the authority of the signer. You are legally attesting, I am the person with the right to do this.
And what's the third thing?
Confirming the absence of objections.
The absence of objections. What does that mean?
It means you are often signing a legal statement that says something like, to my knowledge, I know of no other family member with equal or higher standing in the legal hierarchy who objects to this cremation.
So if you sign it, knowing your brother is against it.
You are potentially committing perjury. You are taking on the legal liability.
Wow. So it's a legal safeguard against unauthorized disposition. It protects the crematory.
Correct. It puts the liability squarely on the shoulders of the signer.
And what about burial permits? How do those work?
Burial permits are slightly different. They're still essential, but the process is a bit more straightforward. They're issued by local authorities, like the health department, but only after the death certificate is filed.
Okay.
The constraint here is on the cemetery. A cemetery cannot legally accept remains. They cannot dig the hole. They cannot lower the casket without that specific physical permit in their hands.
It sounds like a relay race. The doctor passes the baton to the funeral home, who passes it to the health department, who passes it to the cemetery.
That is exactly the workflow. And if you break the chain at step 1, if the doctor is on vacation and can't sign the certificate for 3 days, then step 4 just never happens. The whole race stops.
This is fascinating, but it's also deeply stressful. It makes me want to plan ahead. Which brings us to Section 5, the will paradox and pre-planned directives.
Ah, yes. This is my favorite part of the discussion because it contains the biggest myth in the entire death industry.
Which is the reading of the will seen in the movies.
Yes, exactly that. The family gathers at the grave, everyone cries, maybe it's raining, and then they go to the lawyer's office. And the lawyer opens the will and reads, I, John Smith, wanted to be cremated and have my ashes scattered in Paris.
And everyone gasps.
Everyone gasps because they just buried him in a cemetery in New Jersey an hour ago.
Right, because it's too late.
It's way too late. The will paradox is this simple, brutal fact. The last will and testament is almost always read after the funeral arrangements are already made and completed.
So putting your funeral wishes in your will is kind of useless.
It's not totally useless, but it's incredibly dangerous if that's the only place you put them. A will is primarily a document for the distribution of assets. It's for money and stuff.
Okay.
It has to go through a legal process called probate, which takes time. Funeral decisions have to be made in 24 to 72 hours. The timelines just don't match up.
That is a massive disconnect in people's understanding.
It is. The source calls it a common trap. Families rely on the will, thinking it's the instruction manual, but the manual arrives long after the project is finished.
So what should we use instead? What's the better tool?
Pre-planned directives, or sometimes they're called funeral planning declarations. These are documents created specifically for the funeral. They cover the service type, the music, the religious preferences, cremation versus burial.
Are these legally binding?
It really depends on the state. Some states have specific statutes that make them legally binding. In others, they're not as ironclad as a contract, but, and this is a big but, they carry immense emotional weight.
Emotional weight. What do you mean by that?
Even if the law says the next of kin could technically override the wishes, most families won't if the wishes are written down clearly by the person themselves. It changes the dynamic completely.
How so?
Instead of the family sitting around a table guessing and arguing, did mom want hymns or pop music? Did she want an open casket? Whoa. They're just executing instructions. It removes the guesswork.
The source called this the relief factor.
Yes. And it's so true. Families report profound relief. It prevents the conflict we talked about earlier. If mom wrote it down in her own handwriting, the siblings don't have to fight about it. They can just look at each other and say, well, that's what you wanted. End of discussion.
It's her final say.
Is her final say.
I want to circle back to something you touched on, the difference between an executor of an estate and the next of kin. Because I think a lot of people assume I'm the executor, so I'm in charge of everything.
That is another huge point of confusion, and it causes a lot of problems. Being named executor in a will gives you power over the estate, the bank accounts, the house, the debts.
The financial stuff?
The financial stuff. It does not automatically grant you authority over the body.
Really?
Really. Unless the state law or other specific documents like a designated agent form say otherwise, the authority over the body stays with the next of kin, the spouse, the children, regardless of who the executor is.
So you could have a really messy situation where the executor is, say, the deceased's best friend who controls the money to pay for the funeral.
Right.
But the estranged son is the legal next of kin who controls the body.
We see it all the time. The friend says, I have the money. He told me he wanted a big party. The son says, I have the legal right to the body, and we are having a quiet, traditional burial. And if they don't get along, it's a disaster.
It's a legal standoff.
And a complete standoff.
So the proper use of the will, use it as supporting documentation. Is that the takeaway?
Exactly. Use the will to clarify who you want to be in charge, and definitely use it to set aside money to pay for the funeral, but do not rely on it as the primary instruction manual for the immediate timeline.
Okay, let's go a little deeper. We've covered the main documents, but then there are these ancillary documents and special circumstances in Section 6, things like advanced healthcare directives and DNRs.
Right. These are usually thought of as living documents. They're about medical decisions while you are alive, but they have a huge impact on what happens immediately after death.
How does a do not resuscitate order affect the funeral? That seems like a leap.
It affects the location and the process of death. If you have a valid DNR and you die at home peacefully, the paramedics, if they're even called, will respect that and not attempt resuscitation. This means the death occurs at home.
Okay.
If you don't have it, they are legally obligated to begin resuscitation and transport you to the hospital where you might be pronounced dead in the ER.
And that changes who signs the death certificate.
Precisely. If you die in a hospital, the attending physician there signs it. It's pretty routine. If you die at home under hospice care, the hospice nurse and doctor handle it, also routine. But if you die at home unexpectedly with no DNR and no recent medical records, the police and the medical examiner get involved.
And that leads to delays and complications.
Big time. Deaths outside of medical facilities often require extra verification. The police might treat the scene as a potential crime scene until it's proven otherwise. This can delay the release of the remains to the funeral home by hours or even a full day.
So having those medical directives available for the paramedics isn't just about your medical care at the end. It's about ensuring a peaceful and smooth transition to the funeral home.
Yes, it streamlines the handoff from the living world to the postmortem world.
What about the ID check? The source mentioned funeral homes asking for things like a photo ID, social security number, and even a birth certificate for the deceased. Why would they need a photo ID?
It goes back to that theme of accuracy. The funeral director needs to be 100% sure they are caring for the right person. But it's also about filing that death certificate. They need the name to be the exact legal name that matches the Social Security Administration's records.
So if my driver's license says James, but I've gone by Jim my whole life, and the family tells the funeral home my name is Jim.
And they put Jim on the death certificate, then Social Security might reject the death notification. Or the bank might look at it and say, we don't have an account for a Jim Smith. We have one for a James T. Smith. It causes a cascade of administrative chaos.
I see.
So they ask for the birth certificate, the Social Security card, the ID, to ensure the spelling, the middle names, and the numbers are perfect from the start.
That is a level of detail I never would have considered.
It's the detail that saves you weeks of headaches down the road.
Let's touch on special legal considerations, specifically deaths that are under investigation.
Right. This is when the medical examiner or coroner steps in. This happens with accidents, homicides, suicides, or just sudden, unexplained deaths of otherwise healthy people. When the ME has jurisdiction, the family essentially loses control of the timeline.
The family can't plan the service.
They can start planning it, but they can't set a firm date until the ME releases the body. And that can take days or, in complex cases, weeks, depending on autopsies and toxicology reports. The ME's investigation takes precedence over everything.
And veterans. There was a note about them.
Yes, veterans are entitled to a whole separate layer of benefits, things like free burial in national cemeteries, a government headstone, military honors like a flag-folding ceremony. But to get any of those, you need the form DD-214.
The discharge paper.
The discharge papers. And if you can't find those papers on the day of death, you might miss out on those honors entirely, or you might have to pay for a private burial and try to get reimbursed later, which is a bureaucratic nightmare in itself.
So find the DD-214 now.
Find it now. Put it in the folder with the birth certificate and the will.
And finally, religious and cultural requirements. This seems like a potential point of conflict with the law.
It can be. Some traditions, like in Orthodox Judaism or Islam, require burial to happen very quickly, often within 24 hours.
But the civil law requires a death certificate and a permit, which takes time.
Exactly. There is a tension there. This is why it's so important to work with a funeral professional who knows the local system inside and out. They often have established relationships with the doctor's offices and the local health department to walk through the paperwork on an expedited basis to meet those religious needs.
So a good funeral director is essential in those cases.
A lifesaver.
That's a great segue to our last big section, Section 7, the roadmap. We've probably scared everyone with all the potential pitfalls, so now let's help them move from chaos to control. What are the common mistakes we need to avoid?
Okay, mistake number 1. Assuming verbal wishes are enough. He told me he wanted to be cremated. That holds very little legal weight in court if the next of kin disagrees. Write it down.
Mistake number 2.
Waiting too long to request those death certificates. The moment you can order them, order them. Don't wait.
Number 3.
Relying solely on the will is the instruction book. We've covered that one. It's a trap.
And the big one, I think, is overlooking who specifically has the legal authority to sign.
Yes. Don't assume. Find out what your state's hierarchy is. Have the conversation now so there are no surprises.
Okay, so let's lay out the recommended sequence. The source material gives us a pretty clear step-by-step list. What's step 1?
Step 1. Secure medical certification of death. You can't do anything. The clock doesn't even start until a doctor or medical authority officially pronounces the death.
Step 2.
File for and obtain the death certificates. And get those 10 certified copies.
Right. Step 3.
Confirm the legal authority for disposition. Figure out who is the boss of the body according to state law. Is it a spouse? Is it the kids? Get that clear.
Step 4.
Review any pre-planned directives. Check if there are specific written instructions for the funeral itself.
Step 5.
Locate the will. Not for the funeral instructions, but for supporting information, like who the executor is and if money was set aside.
And then, and only then.
Then you can confidently proceed with making the funeral arrangements.
It seems so obvious when you lay it out like that, but in the moment, in the grief and the chaos, I imagine people jump straight to the last step.
They do. They walk into the funeral home and start picking out caskets before they've even found the will or confirmed who's signing. And that's when they hit that legal stop sign we talked about.
Let's talk about the role of the professionals here. The source mentions the funeral program site and the importance of choosing the right people.
Yeah, funeral directors are often misunderstood. People sometimes think of them as just event planners or salespeople, but their most critical role, really, is as navigators of this legal complexity.
They're the ones dealing with the health department, not the family.
Right. They're filing the forms, getting the permits, verifying the authority. A good funeral director is part paralegal, part grief counselor, and part event planner. They are the buffer between your grieving family and the bureaucracy.
So finding one who understands both the emotional and the legal landscape is absolutely key.
It's everything. You don't want someone who's just good at arranging flowers but sloppy with the paperwork. That's a recipe for disaster.
So after all this, what does it all mean for us? We've been talking for a while now about forms and permits and laws.
It means we need to shift our mindset.
Shift to how?
We need to stop looking at these legal documents as cold and impersonal. I know a death certificate feels clinical. I know a cremation authorization form looks like a tax return. But these pieces of paper are the foundation of a peaceful goodbye.
Clarity enables compassion.
That's the synthesis right there. When you have the documents secured, you have reduced anxiety. You have fewer delays. You have less conflict between siblings. And what does that give you? It gives you the space and the freedom to be emotionally present.
You aren't on the phone arguing with the bank. You are sitting in a living room holding your mom's hand.
You aren't trying to track down your estranged brother to sign a form. You are sharing stories and memories about your dad with your sister.
That is powerful. It's about clearing the administrative deck so the real work of grieving can actually happen.
Preparation doesn't diminish grief. It doesn't make it hurt less. But it absolutely prevents unnecessary hardship and stress from being layered on top of it.
I think that's the perfect place to land this conversation.
It really is the core of it all.
Before we go, I want to leave our listeners with a final provocative thought. We've talked about legal preparedness as a practical, logical thing, but I want you to consider that it is actually a profound act of love.
It's a gift.
A true gift. By sorting this paperwork now, today, while you are healthy and of sound mind, you are gifting your family the freedom to grieve you later. You are taking this immense burden off their shoulders before it even exists.
And here is the question for you, the listener. If something happened to you today, right now, would your family have a roadmap? Would they open a drawer and find the key?
Or would they be sent on a frantic, stressful scavenger hunt in the middle of their worst nightmare?
A roadmap or a scavenger hunt?
That is the choice.
It's a choice you can make for them today.
Thank you so much for breaking all of this down with us. It's heavy stuff, but it's so, so vital.
My pleasure. It's knowledge that really empowers people.
And thank you to you, the listener, for joining the Funeral Channel Network podcast for this deep dive. We hope this helps you navigate the tough stuff so you can focus on what truly matters. We'll catch you on the next one.
Take care, everyone.